Just to briefly introduce the presenters, I'm Catherine Evans. I'm from Marsh, Canada, and I'm with our cyber risk practice. We also have Imran Ahmad, who is a partner with Taylor Thompson, and we have Joanna Reed, who is a senior vice president at Marsh and is involved with the ADR portfolio of insurance. So thank you everyone for your time, and thank you very much to Adric and Janet Mackay for inviting us to present to you today. To give you just some housekeeping items to start off with, we are going to run through the presentation, and we will be accepting questions after the presentation is over via email. So at the end of the presentation, Joanna will give you an email address at which any further questions can be addressed, and we'll be hopefully putting together an FAQ document with some additional information once the presentation is completed. So in terms of what we're going to cover today, we're going to talk a little bit about the threat landscape, what cyber threats are, what we need to be concerned about, what is going on in the environment. We're going to talk a little bit about the legal and regulatory landscape, talk a bit about insurance coverage, although we won't go into that too detailed. We'd want everyone to stay awake through the whole presentation. And then we're also going to talk a little bit about the best practices, both from a pre-breach and a post-breach perspective. So to kick things off, I'm going to start by talking about the threat landscape. Sorry, we're just having a bit of a glitch. Yeah, there we go. Okay, thank you. Yeah, I don't know either. So we're going to start off by talking a little bit about the threat actors. So the reason that this is important is that it's important to understand who these bad actors are and what it is they want, because you can't start to think about your own risk and how to protect yourself unless you understand, who these people are, what it is that they could potentially be seeking to get from you. So this is a slide that was put together by a partner firm of ours called Mandiant, who specialize in breach response and forensics. And they've essentially classified the threat actors into 5 different categories, depending upon their levels of sophistication and their motivation for seeking the information. So as you will see, they range from nuisance actors, which are essentially either operating out of an annoyance motivation, so they're just trying to disrupt people to see if it's possible, or from a ransom perspective. So fairly unsophisticated pieces of ransomware would fall into this category, as would, if anyone is familiar with the term, a distributed denial of service attack, which is essentially where pieces of equipment such as security cameras or computers are essentially weaponized to just all try to ping off specific websites or specific networks at one time. They don't do any particular harm other than just dramatically slowing down the operation of those websites, thereby potentially impacting a business. Generally, those are not targeted attacks, and they're fairly unsophisticated. The next level would be the hacktivist type of attack, and these are typically motivated by a specific ideology. So these would be things like hackers that take over a website and paste defamatory material on it, or any other type of ideologically motivated attack. Typically, there's not a significant financial motivation or financial gain in these types of these instances. It's really more for publicity and to embarrass the potential target. The next is the cybercrime, and this is definitely a financial gain motivation. And this is what we would consider organized crime of the 21st, 22nd centuries to be. So it's much more profitable for organized crime to try to steal credit card information that they can then monetize, or steal any sort of private confidential information in the hopes of being able to monetize it. It's much more financially beneficial for them to do that than some of the traditional money-making schemes that they had engaged in previously. The next 2 levels are the espionage and disruption types of threat actors. And these are really these are quite sophisticated. They do what is typically called an advanced persistent threat. So these are often nation states. These can sometimes be terrorist organizations. These are quite sophisticated actors here, and typically they have they'll have hundreds and hundreds of people working behind the scenes trying to specifically gather certain information, generally from large international corporations, governments, or in certain cases they are looking to destroy or disrupt critical infrastructure. So in thinking about how we wanted to present this to you guys, I would suggest that the risks that are most likely going to be facing your membership would be more from that nuisance and cybercrime perspective. Relatively unsophisticated attacks that are either exploiting a vulnerability that they are already aware of, not necessarily targeted at a specific individual, but for example, they might have found a certain vulnerability within a certain piece of software, and they're sending something out to try to find that vulnerability wherever it may be. So they're not concerned overly with who it is they attack. They're either just testing to see if it's possible, or they're hoping to be able to monetize it in the end. But again, these are not typically going to be overly sophisticated, advanced persistent types of attacks. So now that you have an understanding of what it is, who's out there and what it is they're trying to get, the question then becomes, why do they want these things? What can they do with them? So to understand that, it's helpful to understand a little bit about what is called the dark web or the dark net. And it has a number of uses, but it's most predominantly known for being essentially a criminal marketplace. So it's almost like, I'd say maybe like an eBay type of thing, but for criminals or for nefarious activity. So on the dark web, you can find people that will do almost anything you want. And the reason that I've brought this up is to give you an example of some of the services that you can find on there. Because ultimately, individuals don't have to be overly sophisticated to engage in these types of behavior. So this particular one is a marketplace that is, you can find different hacking services available to you. So if you're looking for someone to provide a password cracker because you have found a computer you want to get into and you can't figure out what the password is, there's a service available on here to purchase. This is another example. This is more of a full suite of services offering. So this particular entity will hack a smartphone, or they will hack emails, they will hack social media, and there is obviously a price menu associated there, payable in Bitcoin. Now this is a little bit old. I don't think the prices for these would be nearly this much given what Bitcoin is valued at these days, but it's just to give you an idea of really the full marketplace that exists out there. The pricing is scalable. It's a full suite of services, and typically there is some sort of money-back guarantee available with these services as well. The last one I wanted to show you was specifically a ransomware service, and I thought this might be of interest because I'm sure that this is something that is prevalent within your group. This is the largest type of loss, or the most frequent type of loss that we see from clients, is with the extortion or the ransomware. So this is an example of ransomware as a service. You can pick your package. There's certain add-ons that you can add. There is a help desk should you run into any issues once you've tried to deploy this. So all of this is to say that ultimately, it's not as though there's a number of very, very sophisticated masterminds out there and a limited number of them targeting certain things. This has become very, very prevalent because essentially anyone out there that is interested and has access to the dark web is able to purchase these services at relatively nominal fees. So ultimately, the reason that this matters is because we need to make sure that people understand that the cyber risk isn't going anywhere. If anything, it's increasing daily, and that as organizations and businesses rely more and more upon technology to continue their operations, this is a risk that everyone needs to start thinking about and to be aware of. And not to be overly cliched, but the one thing that we do here all the time at cyber conferences is it's not a matter of, it's a matter of when. So it's important that everyone does start to think about their cyber risk and how they want to try to manage it. So with that, I'm going to pass it over to Imran to talk a little bit about the legal and regulatory landscape.
Thanks, Catherine, and that was a great overview. So just by way of quick introduction, and before I get started, I want to thank the organizers of ADRIC, and in particular Janet Mackay, and as well as Mike for the kind introduction at the top of the presentation. You'll get a copy of the slides, I'm sure, following this presentation, but I do want to mention that I will go through some of the key highlights a bit more quickly so we can focus on the best practices that you can implement within your organization. So just by way of quick introduction, I know Catherine mentioned it, I lead nationally the cybersecurity law practice at Miller Thompson. And maybe I'll just start off with this. About 5 or 6 years ago, when we formally set up our cybersecurity practice, we would run these annual surveys of our clients. So most law firms do this in any event. They'll reach out to their clients, either general counsel, CFOs, risk managers, and ask them what are the key issues that they're going to be concerned about over the next year or so. And historically, before Target, Home Depot, and Sony happened, which are the major breaches that were reported in the media, typically privacy and cybersecurity or data protection is somewhere at the bottom of the list, typically around number 10 or 11 on ours. What we noticed was after those major breaches, and consistently ever since then, over the past few years, cybersecurity has been number 1, 2, or 3 ranking in terms of priorities for all organizations, large or small. So the awareness level is certainly there. The bigger question is, what do we need to be aware about specifically in terms of our requirements from a business standpoint? We're going to get into that a little bit in the course of this presentation. So maybe I want to start off with this. Some of the conversations we typically have with our clients is, they'll assume that they don't hold a lot of valuable information. They may have some information about clients, they may have some information about business plans, but generally speaking, why would anybody want any of the information that we hold? And just to give you a bit of an idea, the first picture you see on your left gives you an idea, if you're dealing with individuals, the type of information, the quality of the information you can get. So under Canadian privacy law, you'll see there are 2 broad categories of information or data which are highly valuable. The first one is related to financial information. So think of social insurance numbers, think of your credit card information, and so on. And the other categories relate to health records generally because of the sensitivity around that type of information. So those are, just from a starting point, highly sensitive bits of information, which are typically targeted by cyber criminals. Unfortunately, although we as individuals may be valuing them at a very high level, they're not valued that much on the market. And on the right side, you'll see a picture which gives you an idea of the price lists that are being sold on the darknet that Catherine was referring to earlier. So if somebody was to get your social insurance number and date of birth information, that would only be worth $3 on the darknet, which is a very small amount if you ask me. But if they can get your credit report, for example, that's $150 a pop. And so you get a sense very quickly that the quality of the information, so when Equifax occurred, because the quality of the information was very high, that was valued very heavily on the dark market. So just to give you an idea, this is the type of information that's being traded.
I'm sorry, just to interrupt for 1 second. If we could just ask everyone if they could please mute your microphones until the end of the Q&A session. We've had some feedback that perhaps there's some background noise. Thank you.
So I'll carry on. One of the examples I wanted to talk about, because we do get a lot of these as well. So Mossack Fonseca, or the Panama Papers, which were heavily reported in the media. On your right side of your screen or of the slide, you'll see sort of the email exchange that occurred between the law firm and the hacker. And you'll see it's very polite, but very clearly says that we have access to your information and that we want something for it. And this is not uncommon. We've had situations where either law firms with few number of lawyers or paraprofessionals would get these kinds of attacks occurring within their organization, and this is the type of dialogue that they would have. I'm not going to get into the Panama Papers into too much detail because I want to keep some time for the best practices piece, but really the key here is the law firm itself had tons of information that was extremely valuable for their clients. They had financial information, they had identification information, and all that information not only got stolen, but got leaked into the public sphere. And as a result, the law firm suffered significantly from a reputational and then ultimately in terms of an operations standpoint as well. So maybe I can just spend a couple of minutes here talking about why hackers and cyber criminals in general are extremely interested in targeting legal professionals. So as a general rule, legal professionals, and it could be in any sphere that you wish, are privy to very confidential information. It could be intellectual property, employee records, trade secrets, know your client information, financial information, etc. And so you may get this information in the course of any of the files you may be working on, but that information is extremely valuable. The other piece is, especially with firms which are limited in terms of headcount, hackers feel that the infrastructure within those organizations are a bit weaker. So a lot of smaller firms, for example, that we've advised in the past, will be migrating to the cloud or may have a single server in one physical location. And it's very easy for many of these cyber criminals to target them in a very clear manner and steal the information that they're looking for, or as Catherine mentioned, ask for a significant ransom if they want access to the information that they have access to. So I'm very quickly going to go over the next 3 slides, but just to give you an idea, historically, Canada had been a bit quiet, and just generally globally, the focus on cyber had been a bit less pronounced until about 3 or 4 years ago. And you'll see over the next 2 slides that in Canada, United States, and in particular Europe with the new general data protection regulation coming in, there has been a proliferation of legislation, regulations, and guidance and standards that companies and organizations of all sizes need to comply with. Canada, as a general rule, as you can imagine, being a federation, is a bit of a mosaic when it comes to privacy legislation and data protection laws. You've got our federal legislation in the private sector, which is PIPEDA. And then you've got Quebec, Alberta, and BC that have legislation which are deemed to be substantially similar. And then in addition to that, you've got health privacy laws that are applicable provincially. I won't go through all of these in any great detail because you'll be getting a copy of this presentation. But the key takeaway from these 2 slides is there's a global trend towards data protection and an expectation that the moment you get access to client information or any information which is either confidential or has a privacy component to it, that you as a collector of that information, a custodian of that information, will be implementing steps to protect it. It's not simply a question of storing it within your database. It's now to demonstrate that you've actually taken those additional steps to protect it because of the sensitivity that goes along with it. One quick point on the Digital Privacy Act, and I think this is an important one. I take you back to June 18, 2015. The previous administration had passed legislation called the Digital Privacy Act, which amended our privacy law in a very meaningful way. Although most of the changes came into effect at the time, 3 key changes are going to be kicking in most likely this year. And number 1 is notification to the Privacy Commissioner and the individuals who may have suffered harm, as well as any third party that may be affected by the breach. So what does that mean exactly? Just to give you a bit of a contrast to the model that we have right now in Canada and in the US. In the US, you've got 48 states that the moment you have a breach, you need to report. You need to report it not only to the regulator, but you also need to report it to the affected individuals. So if you're a journalist or if you're a class action lawyer in the United States, every morning you can get up, you can type in on Google, Attorney General, California, data breach, and you will get every single daily notification that's been posted and will help you either file a new case or start a great story for the publication that you're writing for. In Canada, thus far, it's been a bit different. What happened in Canada is our privacy legislation required us only to notify the commissioner, and if under the commissioner's guidance, then to notify the individuals. And that was fine for a long time, but now the move is towards the US model, where not only are we going to be required to notify the commissioner, the regulator, but also we will need to self-assess whether the impact of the breach is going to have a negative impact on the individuals that are suffering the harm, potentially, whose information was compromised. And in that case, you'll need to notify them as well. So the litigation exposure or the liability exposure from a breach has just gone up significantly. The other requirement that's going to be key as well is the fact that you need to keep a record of every single breach that has occurred within your organization. And that's a very onerous requirement. So we think of the data breaches, the gentleman or the kid who's sitting in a basement with a hoodie on trying to break into your network and steal data. That's the classic view that people have. But it could also be as simple as somebody from your company or your organization going to a conference or a trade show, losing a USB key or a laptop, or having their items stolen from their car, which may have had client information on it. And at that point, you would have to keep a record of that. If you fail to do that, either that or notify the individuals in the previous point, then there are significant fines of up to $100,000 for failure to comply with that. They're not enforced yet, but it's coming most likely later this year. The next 2 slides are just a quick snapshot of the litigation exposure that may occur if a breach ever occurs. So privacy related, either people snooping into other individuals' accounts or actual theft of data or unauthorized access. This is from a statutory standpoint, which is fine. But the next slide talks about how the courts now are becoming much more open to receiving new types of torts related to these type of incidents, related to cyber or data breaches. And what is concerning at some level is the fact that courts are willing to entertain them. Historically, to introduce a new type of tort would take many attempts and many, many years. What we've seen is, especially in Ontario, there is a willingness to receive new types of torts, consider them, and then implement them relatively quickly, and then have other parties rely on them on a going forward basis. So the key takeaway from the past few slides that I want to highlight is there's going to be regulatory exposure. There's going to be the fact that you need to disclose information of a breach to affected individuals. That will result in statutory rights for litigation, potentially, but also the courts are going to be listening to torts that can be brought before them for these type of claims. I'll hand it over to Catherine for the next few slides, and then I'll come back when we talk about some of the best practices that can be implemented.
Thanks, Imran. So I'm going to spend a little time now and talk about the insurance coverage that is available out there to deal with some of these risks. So this slide outlines the traditional insurance policies, the traditional insurance portfolio that many organizations would typically purchase. And it looks at what of these cyber risks are covered by these policies and where would that be. So from the perspective of the people involved on this WebEx, there's sort of three key areas and three key risks that I wanted to touch upon here. So the first one is loss of data. So you'll see here under the integrity and availability of your data, it's read pretty much across the board. And the reason for that is that property policies will typically provide coverage for loss of information or loss of data if it's covered by a physical peril, or if it's triggered by a physical peril. Meaning if there is some sort of fire or earthquake or flood that causes physical damage to something, which is what renders that information to be unusable or destroyed and needs to be regathered or recreated, then that is something that can potentially be covered under a property policy. But when we're talking about cyber risks, there is no attendant physical damage that is the trigger here. It's essentially just an electronic or data issue. So there is no way to trigger the property policy to respond to that. The next one that I wanted to touch upon is the confidentiality of third-party data. So data belonging to others that you're required to keep confidential. If that information becomes public, where can we find coverage for any resulting lawsuits? And although general liability policies do typically provide coverage for most third-party liabilities, they also include what are known as data exclusions. So if the loss has stemmed from a data type of situation, or if it's traced back to a data trigger that has caused the problem, such as a cyber hack or a breach of your systems or ransomware, malware, any of those types of things, then that automatically kicks the resulting loss out from coverage under the general liability policy. The last one on here is operational disruption. So the idea that even though nothing has physically happened to your data, if there is some ransomware or if there is some sort of attack on your systems that causes you not to be able to access the information, you're now potentially not able to operate your business. You're not able to generate profits, or you incur a significant amount of additional expense to get yourselves back up and running. And if that type of scenario had taken place as a result, again, of some sort of physical peril, so a fire, earthquake, anything along those lines, then you can find coverage potentially under a property policy for those types of risks. But again, if it's happened as a result of a cyber issue and there is no flood or fire or anything, then you cannot trigger the property policy again. So because of the way traditional portfolios are structured and because of the increased reliance on technology by most businesses, that's driven the desire for some insurance coverage that can respond where these policies have fallen short. So that takes us into a discussion around cyber insurance specifically. So I'm going to talk a little bit now, sort of at a very high level, about what cyber policies can cover generally. So it's easiest to split these up into third-party coverages, meaning coverages where that would respond to scenarios where you're liable to a third party for some sort of financial loss, versus first-party coverages, which is where an insured would be directly out money for expenses that they've incurred. So from a third-party perspective, cyber insurance can cover privacy liability, and it's typically quite broadly defined, where there's anything that you are required to keep confidential that has now been made public. So this would apply to private third-party information, personal information belonging to a third party, or it could be corporate information belonging to a third party, especially if it's subject to any sort of non-disclosure agreement. And generally, the coverage doesn't have to be only, or the information doesn't have to be only in electronic form. So usually this will extend to provide coverage to hard copy files, or if you have any sort of lost laptop, USB key, all of those things. Also, there doesn't need to be any sort of allegation of negligence here. It's typically just an understanding that something had been intended to be private and it has become public. The next piece is the network security liability, and that's essentially a bit of a catch-all within the policies. And it's intended to cover any time that you could be responsible for a financial loss to someone else as a failure of your own network security. So this would cover incidences similar to forwarding on a virus unintentionally to a third party. It could be if you have credentials for a third party's system and you don't keep them secure, so now someone else is able to use them and access that system. If that third party suffers a financial loss and they sue you for it, the policy will respond to that. And the last one under the third party section is the privacy regulatory defense cost. So essentially that's coverage for any sort of investigation and any fines and penalties that are as a result of a privacy issue, as long as it's conducted by a regulatory body.
Oh, yeah?
We're talking about the Office of the Privacy Commissioner, but it can also be others. In terms of the first party coverages that are available, there's quite a few, and this is the area where this coverage is evolving the most quickly. So the first one listed there is business income and extra expense. And what it does is essentially covers you for any loss of profits that you suffer as a result of a cyber breach. So if there is, I don't know, I've mentioned it a few times, but if there is some sort of malware that enters your system and makes you completely unable to continue operating, or significantly compromises your ability to continue generating revenue, then the policy will kick in to provide coverage for that lost revenue, for any additional expenses that you incur in order to continue operating, and for it can also be extended to include your vendors. So if you have a critical IT vendor that you rely upon in order to continue operating and they suffer some sort of loss, then it's possible to also extend the coverage out so that your loss of profits in that scenario can also be picked up. The next one is data asset protection, and that's essentially coverage to recreate any data that's lost as a result of a cyber breach. So if there is a corruption of data or data is completely wiped, then the policy will respond to pick up the cost to recreate that data. The next one is event management, and this is a very central aspect of the coverage. And essentially what it is the financial cost to manage an incident. So it covers you for all of the incident response costs required if you have a breach. So this would include involving a breach coach, which is a privacy lawyer like Imran, to sort of quarterback your response, to help you understand what notification requirements there are, and to help engage all of the additional vendors that you're going to look to secure in order to respond to the breach, in the hopes that that web of privilege that you have with Imran then extends to those other vendors as well. It also would include coverage for a forensics firm. So if you need to engage a third-party provider to figure out exactly what information has been compromised and how they got in, and how are they still in there, how to get them out, all those sorts of things, that can be picked up by the coverage as well. It also will provide notification costs. So if you need to notify any individuals that their information has been compromised, as well as potentially setting up a call center should there be a large enough affected group that you need to consider something like that, as well as offering credit monitoring to anyone whose information has been compromised, which is now considered a central part of any good breach response. Additionally, it will also provide coverage for any PR work that's needed to try to manage the communication surrounding the event. Additionally, these policies don't just give you the funds to manage this, but they also give you a web of vendors that have already been pre-screened by the insurers, where there are additionally preferential rates in place, so that you're not in a position where you've now just suffered a breach and you're trying to go out and source all of these vendors. It's all in place for you and ready to go should you need it. And then the last piece here is the cyber extortion, and that's very similar to the event management coverage, but it also includes the cost to pay any ransom should you choose to do that, as well as the cost to procure the Bitcoin, set up a Bitcoin wallet, find a broker, all of those All of those components to the breach response or to the extortion response have costs associated with them, and the policy will pick up coverage for those as well. And the last thing I wanted to cover were some common exclusions under the policy, because there are certain things that insureds often think should be covered by the policy and are surprised to find out that they're not. So the first one is the idea of reputational damage. So the policies will provide loss of profit cover during the course of an outage and then for a set time period after the outage typically. But if 6 months after the outage, clients are moving their business away from you, or your profits aren't where you thought they would be because there is some sort of impact to your reputation because of what's happened, then the policy doesn't extend to cover that. The policies also typically don't extend to remediate the problem. So like any other type of insurance, the policies are designed to take you back up to where you were before the loss. So if there was a hole in your security before there was a loss, in theory, these policies don't cover closing off that hole. In practice, that's typically a point of negotiation with the insurers because they don't generally want to leave that hole there. But purely according to the policy wordings, there is no coverage for that. The next one is theft of intellectual property. And to be totally clear, this should probably say theft of owned intellectual property because it doesn't cover if there is some entrance into your system and they steal your own intellectual property and you suffer a financial loss as a result. There's no coverage for that financial loss. If you're holding third-party intellectual property and that's stolen and the third party suffers a financial loss, there is coverage for that. So it's only your own intellectual property if it's compromised is not picked up. And then the last one is social engineering, which essentially just means the idea that someone spoofs someone's email address and convinces you to voluntarily send funds to a third party. So we hear about this in the news all the time right now. Typically, someone spoofs the CFO's email address and instructs wire payment be made to an offshore account somewhere, and then the accounts payable person does it, and that money is not recoverable. So that is typically considered to be a crime loss by insurance companies. So there is coverage available in the marketplace for that, just not through cyber policy. So that was what I wanted to cover from a cyber perspective. In terms of the coverage available right now through the ADR policy, there is a $25,000 limit available for a number of the coverages that I've spoken about. Part of what we will be doing this year is working on trying to broaden that out as much as possible and enhance it where available. But if you have any questions about the coverage available under the policy, please feel free to contact us. And I will again now pass this off to Imran to talk about best practices.
Thanks, Catherine. So we've got about a little less than 10 minutes that I want to go through some of the best practices that can be implemented before a breach occurs and afterwards. But I had a couple of quick comments beforehand. So first of all, what kind of cyber threats would organizations be facing? And I know Catherine and I have touched on a couple of them, but just to give you an idea, it's not static, it's evolving. We've talked about ransomware. This is basically locking down your computer or asking for a payment to be made in exchange for giving you back access to your own data. DDoS attacks, denial of service. This is where junk traffic brings down your website. That could be devastating, especially for websites which are transactional. Wire fraudulent transfers are very common these days, as Catherine mentioned. But the point in all of this is, even within those broad categories, we're seeing significant changes. So for example, a couple of years ago, it's very common to see multiple ransomware attacks in the range of the ransomware anywhere between $5,000 to $10,000. What we're seeing now over the past 6 months or so is ransom, which are in the $250,000 range. That can be negotiated with the hacker, if you can believe that, but the fact that the amounts have increased significantly, and the fact that they're not just basically encrypting your data, but encrypting critical data, that they've actually done some homework and figured out what is actually valuable to you, and then encrypt it so they know you're going to pay at the end of the day, is a big deal. And that can be a difference between having a practice that can actually survive an attack, another that cannot survive post-incident. So, the insurance piece that Catherine touched upon can't be overemphasized. It's an important component of a risk mitigation strategy. So I just wanted to put that out there before I got into that. The second piece I wanted to mention was a couple of years ago, our firm undertook a pretty lengthy exercise where we pulled out every single case we could find by Canadian courts of a data breach, a privacy incident, a cyber attack, if you wish, and try to figure out our way backwards. What were the courts looking for? And what was interesting, what came across was that the standard that they expect is not one of perfection. The idea is not that once the data is in your possession, that you're absolutely going to safeguard it without any fault for the end of time, but rather the expectation was you were acting as a diligent and a reasonable organization and putting reasonable protocols in place to protect that data. And so what you see in front of you on this slide are really 6 broad categories, and they may seem very intuitive when you look at it on the face of it. It gets a bit more complicated when you sort of customize that to your organization's needs and how you actually operate. In most cases, the first one, which is know where you stand, seems evident. What data do you hold and where do you hold it? That can be complicated. You don't know exactly where the data is held, or it's held in different places. Could be perhaps on your Google Drive, or it could be on a physical server, or it could be in the cloud, or it could be a combination of all of that. It's never a clear stream. So one of the things we typically ask clients to do, or we work with them on, is to make sure that there's a clear mapping exercise or whiteboarding exercise that they go through, knowing exactly where the data is and the type of data they hold. So if you're getting client information in your possession and you know it's intellectual property, which has a very high value to it, or has a lot of personal information, which has a high value to it, or is coming from Europe where there's a very strict standard for GDPR, you want to make sure, A, it's secure, and you want to know where it is, because if somebody comes asking, where did you store it and whether it was encrypted, you want to be able to give them a clear answer very quickly, not figure it out on the fly. The second one here is audit and test security. And this again may seem intuitive, but there's some layers to it. First of all, we recommend, just as a general practice, to have legal counsel involved in this process for privilege purposes. You may go through a process where you get a third party coming in and doing an audit of your processes or your protocol, your risk profile, and may identify significant gaps. If you don't have legal counsel involved, you may have a situation where very shortly thereafter, you have an incident, you may end up in litigation, and in discovery, they can compel you to produce that risk assessment document that was produced, and you would have no choice but to hand it over, essentially giving opposing counsel a roadmap to all the deficiencies, which may or may not have been material to the incident that was at hand. So audit and test security on a regular basis. The third one, again, educate and train staff, and there are multiple layers to this one as well. We often rely on staff, and it's not staff's mistake, but basically they have a lot of demands on their time and often very limited resources or limited time to respond to those demands. They may be getting a ton of email requests coming from clients or other vendors or other partners, and when the information comes in, they may not pay great detail to the emails. So if 1 or 2 letters are switched and it's coming from a cyber criminal who's trying to spoof someone through a social engineering attempt, like Catherine mentioned, well, they may be a victim of that. So having employees trained specifically to be able to flag and identify these types of incidents is going to be key. And I'll give you an example, which is personal and which I share with folks on a regular basis. So as you know, today we're giving you this presentation. It was advertised and promoted that we would be speaking between 2 and 3 o'clock. So it's reasonable for a hacker who was online, who was tracking me, to know that Imran's most likely not going to be in the office today between 2 and 3 o'clock. He or she could then very easily call Miller Thompson's general telephone line and ask for Imran Ahmad's assistant's email address. And that's something we hand over in any event. That's not private information in any way. We want our clients to have access to us. Now, that hacker could go online, create a Gmail account or a Hotmail account, send it to my assistant, claiming to be Imran, and saying, I've got this really important document that just came in, or here's a file I need you to print out for me the moment I walk in after my presentation. Can you please have it on my desk, because it's essential that I look at it. And if she's not diligent enough, or she doesn't have parameters under which she would not accept to open any attachment from a non-Miller Thompson website or email access, email domain name, well, at that point, you may be compromising your entire network. So having that training and having your employees and staff clearly identify and then take the right steps to deal with those incidents is really key. The fourth one is probably the one we get the most questions on right now. Where are the organizations that can deal from A to Z all of their needs? They'll typically be relying on third parties for services. So it could be somebody who may be helping you with marketing and advertising, your practice or your day-to-day activities. Could be a cloud service provider. It could be someone who's managed services. So you may have a virtual CISO or an information officer, for example, managing your IT. Well, those are all third parties. And what you want to do is you want to understand what that relationship looks like, because the moment you hand over your data to a third party, although you're technically still responsible for it, you become more vulnerable at that point. So if that third party doesn't have robust security in place, they don't have protocols and policies in place, and they get compromised or they have a cyber breach, well, at that point, you're technically, because you're the one who's collecting the information, on the hook. So you want to have an ability to be able to get some visibility into their activities. You want them to notify you immediately, typically between 24 to 48 hours. You want to have specific clauses in terms of cooperation of an investigation if you have to do an investigation. You want to be able to understand who's going to pay the bill at the end of the day if you do get forensics and other people involved. Do they have insurance or don't they? So those kind of things need to be fleshed out very clearly in those types of agreements when you're dealing with third parties. The before last point I have here is having a cyber incident plan, and most organizations will have some kind of a business continuity or a disaster incident type of plan to deal with those type of situations. But a cyber incident plan is very unique given the type of incidents that can occur. You know, we talked about DDoS, we talked about ransomware. Those are very different than some of the other types of disasters that may occur within an organization. So having a clear plan and having it clearly outlined in what sequence do you call whom? You know, do you call your insurer first? Do you call your law firm first, or the breach coach first? Do you call law enforcement? And the sequence will matter for privilege reasons, for litigation purposes, and for other purposes as well. You want to make sure you have that down pat. One mistake clients often make is they will pick up the phone and call 911 and ask for law enforcement to help. And unfortunately, no matter how great our law enforcement services are, they're just overstretched. They don't have the resources and are extremely unlikely to be able to come in and deal with your incident and help you get back on your feet. And the last point is cyber insurance. And I just want to underscore some of the points that Catherine mentioned. As a general rule, dealing with a cyber incident is very unique. It's a different type of situation. It's not an IT standard type of issue that comes up. Having the right professionals go in and help out is very difficult and hard to find on the spur of the moment. So having access to that web of vendors that Catherine was mentioning is really key. You want to be able to pick up that phone and say, I need a forensic investigator, I need a breach coach, I need a PR firm, or I need to get credit monitoring in place now. And this is not something that gets dealt with over weeks. It's something that gets dealt with within the first 72 hours. So having the ability to tap into those resources is really key. That being said, although you can get insurance, you still need to do all of the above to be able to limit your risk profile so that you can get better premiums, quite frankly. So you've done all of that, and unfortunately, you've still had a breach within your organization. And so the question then is, how do you respond? And I'll go through this relatively quickly. There are only a couple of points here, but there are a couple of key issues I want to highlight right from the get-go. Number one, organizations are going to be judged by how they manage an incident. So if you have a breach, that's okay, it happened. But you now need to sort of deal with it in a manner where you're going to give all of your partners and all of the stakeholders within your organization and outside of your organization comfort that you're on top of it. So number one, you need to activate your response team. And for organizations that are a bit smaller, they may want to rely on the web of vendors that Catherine mentioned earlier. So to have that breach coach and folks who are advising you and helping you along the way, either to set up a call center, put out a press release, send out a notification, dealing with the regulators, and so on. The next piece is, as you discover the incident, you want to make sure you contain it. You don't want it to spread across the board, and you want to assess what is the severity of it. So can you continue operations, or are you completely paralyzed at that point in time? And having a clear understanding of that helps you escalate the level of severity based on that assessment. While you do that, you also want to be careful that you're not destroying evidence potentially. So a lot of folks will say, well, we'll just go to backups. Well, there's a protocol on how you go to backups without destroying evidence. You want to make sure that you're not causing more issues by just going to sort of a knee-jerk reaction of getting access to your information, but potentially destroying evidence that would be useful or necessary down the road. The next one is notification, and that could be multifaceted. Notification could be to individuals who are affected. Notification could be to clients. Notification could be to the regulator, but also notification to third parties to whom you need to inform that their information may have been compromised as well. And that also feeds into the communication piece in terms of PR, or a call center that you may need to set up, or just direct communication in terms of a letter or emails that you need to send out to the affected individuals. So I'll stop there. I know we're brushing up on time here, but happy to take any questions. But one of the things we've done is on the pre and post breach, we have a matrix of how you can flesh out each one of these items based on the size of your organization, the type of activities you're involved in, regulated or not, and have that very clearly defined. So if that's ever helpful, feel free to reach out.
Hi, it's Joanna Reed here with Marsh. Thank you so much to our special guest Imran today and to our colleague Catherine for the very insightful information session today. I do want to apologize in advance. We are having technical difficulties with connecting to take questions live. So I do apologize to all participants today for that. But we do want to reiterate, as Catherine did at the onset of the session, that we absolutely are open to taking any questions that you may have via email. And then what we will do is we will compile the questions that are received with our formal responses and develop an FAQ that we will distribute through ADR so that each participant today, and of course those that may not have had the opportunity to participate today, to have access to that information. So again, we apologize for that. Any questions can be emailed to my attention, and my email address is Joanna, JOANNA.Reid, REID, at Marsh, which is MARSH.com. And we will endeavor to put that information together and publish that as soon as possible. So with that, I'm not sure, I'm hoping everyone can still hear us. If we would like to turn it back to Michael, if he's got any closing comments for his members. If not, then from our perspective, we will close out the session. Again, thank you to everybody for participating today. We appreciate everyone's time and participation.